welcome to Family Law Practice Workshop Analysis. If you have not subscribed, please consider subscribing, like, share and comment so as you don't miss any update. And if you can listen up to the end of this video, I'm going to give you tips of how you can pass a family law exam. So basically, we are going to be looking at revocation of probate and letters of administration. In the previous week, we looked at how do you apply for letters of probate and how do you apply for letters of administration. We said you apply for letters of probate when a person died and left a will, but where there's no where the person did not leave a valid will, you apply for letters of administration. So the purposes of this workshop, we shall be looking at if you already have the letters of administration, how can they now be revoked? How can they now be revoked or cancelled? So Module 3, Estate Planning, Probate and Letters of Administration, introduce you the practice aspects of estate planning, testacy and intestacy. You are now able to draw valid wills, structure will, and on the other hand, structure trust deed and other for purposes of estate planning, and to draw petitions for probate and letters of administration. You can also appreciate the law and practice of obtaining these grants from court. You can also protect an estate of a deceased person and the interests of the beneficiaries thereof by, among others, caveating an application for probate or letters of administration and taking all the relevant practical legal steps consequent upon caveating a petition for probate or letters of administration. So this was basically the context of week 1, which we looked at. Basically, I believe that you have an idea, but in case you have forgotten, you can go and have a recap on the last video which we posted on Family Law, where we basically looked into through all these things, because in oral exams, this is one of the most lucrative areas where the panelists would want to draw your attention to. So Module 4, Revocation of probate and letters of administration, will enhance your knowledge on protection of estate of the deceased person as well as the interests of the beneficiaries thereof. You will be able to learn the circumstances in which probate or letters of administration can be revoked by court, the grounds upon which a grant will be revoked, as well as the procedure for revocation of these grants before the High Court and before the subordinate courts. You will be equipped with skills of drawing the necessary legal documents, such as the pleadings are required for suits for revocation of probate or letters of administration, presenting and prosecution the relevant suits, as well as extracting and enforcing the resident court orders. So basically, court orders we shall be looking at after the letters have been revoked. How do you go about that? So you should also explore the ADR mechanisms which can be used to settle disputes in these areas of law. They are cheap, fast, save courts and council's time, and preserve not only family relations but also the property of the deceased. So when we talk about ADR mechanisms, we have looked at the negotiation, mediation, among others. Scope of this week's work, principles of law on revocation and annulment of probate letters of administration. We shall basically look at Section 230 of the Successions Act, because Section 230 gives us grounds under which letters of administration or probate can be revoked. So it's important to understand that Section 230, subsection 1, states that letters of administration can only be revoked where there is a just cause. And now Section 232 proceeds to give us what amounts to just cause. That just cause, court will find just cause where the proceedings obtained grants were defective in substance. It means, for example, if you did not issue a notice of application, that means the procedure was defective. Then B, that the grant was obtained fraudulently by making a false suggestion. For example, if you say that you were a son of the deceased, whereas in fact you are not. That a grant was obtained by means of untrue allegations of a fact essential in point of law to justify the grant. That the grant has become useless and inoperative, for example, where the executor has died or executrix. That the person to whom the grant was made has willfully and without reasonable cause omitted to exhibit an inventory. So we also looked at an inventory, that once you have obtained the letters of administration, you must file an inventory under Section 273 within 6 months, and where you have not filed an inventory, then you must it becomes an illegality where you have not filed an inventory. And then we also see a final account which is filed after 1 month. So basically an inventory contains all the properties of the deceased, whereas the final account shows how you are going to be using or utilizing or you distributed those properties. So if where the person has mismanaged the estate, so basically those are the grounds which amounts unjust cause and under where letters of administration or probate can be revoked. So for you to proceed and revoke letters of administration, you must make sure that you are falling under that ground. So it has been retaliated in a lot of cases. We have Victoria Namuda and Prose versus Sulaiman Rukwago. We also have the case of Sanyu Gwangu Musoke versus Sam Gariwonga, and also the case of Narubenga Gladys and others versus Seburuguse, which all speak to the effect of just cause in revoking the letters of administration. So that, among others, is what we shall be covering in the course of this week. The grounds and considerations upon which probate letters of administration can be revoked or annulled. We have looked at that, Section 2 of the Successions Act of the Successions Act. Then we have also looked at the procedure for revocation and annulment of probate or letters of administration before the magistrates courts and for the High Court, drafting all the necessary legal documents for seeking an order revoking or annulment of probate or letters of administration, seeking interim remedies, preparing of inventory of an estate, a deceased person and accounts, and dealing with the assets of the deceased, ADR mechanisms, and the ISCO issues. Students should read and prepare individual notes, renunciation of grants or preparation of an inventory of an estate of a deceased person, accounts of dealing with the estates of the deceased persons, etc. ADR mechanism. In this area of practice, the only interim remedies are available to beneficiaries who are aggrieved by the actions or omissions of the administrator, and annulment of grants and inoperative grants. So we shall look at the Constitutional Sections Act as the applicable law. We have the cases just cause Sanyu Rwanga Musoke versus Galiwonga, like the one we talked about. That case, basically in Galiwonga, Justice Karokora stated that the grant of probate may be revoked or annulled for just cause. There was evidence that the person had got the letters of administration by means of an true allegation that the mother had not left a will, yet in actual sense there was a will. Then consideration for revocation of grant, we have looked at Section 230, which brings just cause. It lists about 4 grounds therein. We have to look at it. Procedure for revocation of a grant, it's basically by the court that give those grounds. So you apply to revoke the grant in the same court that issued that those letters of administration or maybe probate. Learning outcomes: develop ability to advise on revocation of probate or letters of administration, develop the ability to obtain an order revoking probate or letters of administration, recognizing the ethical considerations relating to obtaining an order revoking a grant or probate or letters of administration. So learning outcomes: by the end of this workshop, you should be able to explain the principles on law on revocation of probate or letters of administration, identify the grounds for revocation of probate or letters of administration, do necessary legal documents for seeking an order revoking probate or letters of administration. Basically, here we shall be drafting a plaint and recognize and appropriately deal with ISCO matters that may arise in the process of executing orders of revocation. So the facts for Maria Zirondem. So we have Maria Zirondem. We're saying that Maria Zirondem lost her only child, Maria Birungi. The deceased left twins, Maria and Waswa. Maria Zirondem lives with these children and looks after them. Their father predeceased the mother. The deceased left the following: savings, NSF, land at Ruelo. On 20 years marriage, Zirondem received a telephone call from the legal officer at Chambogo University asking her to visit her office as soon as possible. When she visited the office, the legal officer informed her that she had intercepted an application by Peter Nsumbi for death benefits from Chambogo University in respect of Mary. Peter Nsumbi had, together with his application, submitted a certified copy of probate granted to him by Mukono Chief Magistrate's Court of ID, probate and administrative cause number 224, dated 12th. Mr. Zirondem took a photocopy of the probate to her lawyer, Mustafa Sanga, Williams Street, Kampala City, in Mukono. These records show that Peter Nsumbi obtained probate in respect of the estate of Mary Birungi. Maria Zirondem informed Mr. Saga that Mary Birungi's husband predeceased her Maria Zandom is very anxious because the legal officer of Chambogo University advised her that Peter Subi could easily sell off the Mary's Brunj's property. So basically, those are the facts we have here. We are looking at how basically do you revoke letters of administration given by the Chief Magistrate's Court, because we can see these letters were given by the Chief Magistrate's Court. So here the first question we have to ask is what ground do we have? Because first and foremost, you can see that this person Zandom received a telephone call from legal officer. When she visited the office, the legal officer informed her that she had intercepted an application for Peter Simbi for death benefits. Peter Simbi had, together with his application, submitted a certified copy of probate. So it basically means that this person made an untrue allegation and stated maybe he was the only beneficiary, and that's why this board not to know. So you are a student at the clerkship. Mr. Stang has requested you to give a legal opinion advising the all remedies available to Mary Zandom. So basically here the remedies that are available. We shall look at many remedies which are available to a person who wants to revoke letters of administration. Remember now here what we are looking at is that first and foremost the property is under threat of being sold. So we shall have to lodge a caveat. And then after lodging a caveat under section 123 of the RTA, that any beneficiary can lodge a caveat against the estate of the deceased. Then we can also apply for what we call administration pendulite, because administration pendulite now requires that they can appoint an administrator before the property is being misused. And then another thing, we can apply for temporary injunction and then the interim orders. Those are some of the remedies which are available here for as short-term remedies, because these short-term remedies will help to do what? Will help to stop any transaction on the land. But the fact that it's a magistrate's court, we also have to do citations, because citations helps to bring back the what? The letters of administration which we are granted, what we call citations in the magistrate's court. So the FRAM procedure and necessary documents. The FRAM is of course the court that granted the letters of administration. The grant is where you apply from. The procedure is you have to draft a plaint accompanied by summary of evidence and then pay the necessary fees. So basically here the just cause we have, remember how must have a just cause, will be that the person obtained the letters fraudulently when he alleged that he was the only beneficiary of the estate of the deceased. Yet in actual sense is not. So basically that's what we should have to go about that. Then practical steps which Mr. Sanga should take in order to obtain these remedies. You have to, of course, institute a plaint like they have discussed. If you consider court action necessary, draw the relevant legal documents. The plaint supported by summary of evidence. ESCO issues, of course, the ESCO issues here we are going to be looking at include one. The ESCO issues here include not, of course, making sure that you don't overcharge clients, serving the pleadings to the opposite party, and also doing proper due diligence. Basically, those are some of the ESCO issues we have always looked at. So basically, after having a just cause under section 230, of the Sections Act, then you have to proceed, and then by plaint, so as you can seek for revocation of these letters of administration. So what is important to understand is that the Chief Magistrate's Courts Act, we have the administration of small estates, section 3 for the administration of small estates, states that courts can be revoked or altered for just cause, or maybe where they are in the court which has no jurisdiction, then these letters can be revoked. And from there we shall also look at lodging a caveat. The Administration of Estates and Small Estates Special Provisions also provides you must lodge a caveat in these Chief Magistrates Court. So remember that the Chief Magistrates Court, you go there when you have 50, the property is 50 million and below. So that's what we call Administration of Small Estates Act. That's why it applies in the Magistrates Court Act. But you must have a just cause under Section 230 of the Sanctions Act. And here we are saying, of course, there is fraudulent. They were acquired fraudulently. But the procedure in Chief Magistrates Courts, you must have a citation. A citation, the court, of course, issues a writing to the person who has granted letters, show reason why they should not be recalled. It's provided for under the Administration of Small Estates rules, and also we must lodge a caveat. We must lodge a caveat. We must lodge a caveat under Section 230, under Section 123 of the RTA, the beneficiary caveat, and then proceed. Also, we can put in a temporary injunction, and then we'll go for revocation of letters of administration under Section 230 of the Sanctions Act, as well as asking for damages which has been caused on the estate. So the procedure is to lodge a caveat, issue a citation accompanied by statement on oath, serve a citation to the person who granted letters of administration, draft a plaint accompanied with a summary of evidence. So the necessary documents here will be a caveat, a citation, statement on oath, plaint, and summary of evidence, which shall be drafted in the Chief Magistrates Court for purposes of the necessary documents. Then the ISCO issues, we have talked about the ISCO issues, the ones we always look at in professional conduct. They equally apply here. Including not overcharging your clients, avoiding, making sure that you avoiding conflict of interest, doing proper due diligence, among others. So workshop 2, by the end of this workshop, we should be able to explain the principles overall on revocation of letters of administration in the High Court. So basically, the first workshop deals with the Chief Magistrates Court, whereas workshop 2 deals with the High Court. Identify grounds of revocation of letters of grant. The grounds are the same under Section 230 of the Sanctions Act. Draft pleadings in the High Court. We shall also draft a plaint supported by summary of evidence. Only that the only difference is here we don't have a citation, because citations only apply in the Chief Magistrates Court. Then ESCO issues. My name is Nicholas. I'm 38 years old. I live at Chiumu Village, Masaka District. I'm the son of Yona, who died on 20 years. My brother and sisters died when the boat they were traveling in capsized. My father left the following properties: Sese Brook, his home, 30 acres, 10 acres, Busiro commercial building. In 2024, my stepbrother John Clever Muia made a report of the death of my father to the Administrator General. He lied to the Administrator General that he was the only surviving child of my father. So basically, this becomes a true allegation, which can be a ground as one of the just cause for revoking the letters of administration. All the people who attended the meeting in the office of the Administrator General were not our relatives. He later obtained letters of administration, VD, Masaka High Court. So we shall be in the High Court because you grant letters from the court that issued them. He did not include me or my mother. Muia sold the land known as Busiro to Don Mugaga. Don Mugaga sold his land to Miss Mari at a total 1 billion Uganda shillings. So basically, you can see now here the land has been sold to Don Mugaga. Don Mugaga has sold to Miss Mari. So basically, that means that for purposes of moot, these defendants will be pleading a defense of bona fide purchase of value without notice, but also the plaintiff will maintain that the transaction was fraudulent. You need to do due diligence, so it should be revoked. I wish to recover all this land. Muia should pay me all the money which I have spent and will spend on this matter, and he should be punishable for his dishonesty. I badly need money to pay for bedside nurses, medical insurance, and water. A fortnight ago, Masaka City Council closed my father's building, which is known as Nsimbi Towns, on account of its DPP dated. My father has established plantations of palms on all his land in Kalangara district. Some of the people he had employed on those plantations left for non-payment of their remuneration. Your student and clerkship at Miss Mirembe and Company Advocates, Miss Regina Mirembe, has handed you the file in respect of Yona Maria Nsimbi. The above is a summary of the facts in this matter, which Miss Mirembe prepared after interviewing Nicholas Mwavu. Advise Mirembe on the following: all the remedies which are available to Nicholas Mwavu in the long term So basically, when you look remedies available in the long term, you have to basically go for, you're looking at whether there's grounds for revocation of wills under section 230 of the Sanctions Act, because under section 230, what we have is that once you have a just cause, then you can proceed to revoke these letters of administration or probate. So that's what we shall be looking at, whether Zabo has locus apply for revocation of letters of administration. And then all the remedies which are available to Nicholas Mwavu in the long term. So to revoke the letters of administration under section 230 of the Sanctions Act, the ADR mechanism available to Mwavu, so we can meet negotiation, mediations, among others. The practical steps which Mwavu should take in the interim in order to protect the assets of Yona and Simbi, and also ensure the welfare of his mother and grandfather. So basically here we are looking at the short term. We have to lodge caveats, apply for temporary injunctions and interim orders in the short term. Though the legal documents which will enable you to obtain the long-term remedies, it's going to be a plaint and summary of evidence. A plaint and summary of evidence. And draw the legal documents which will enable you to obtain the remedies in the interim. We shall have to draw a caveat. Basically, we shall have to draw a caveat. On that purpose. We shall have to draw a caveat. Then, what issues might arise in the course of executing these instructions, and how would you deal with them? So issues, we have looked at them to include one, not overcharging your clients, making proper due diligence, avoiding conflict of interest, fiduciary relationships, the best interest principle of the child, among others. Then what issues might arise? Okay, part 2. Part 2 are saying that on 20th, the High Court of Uganda at Masindi, in admission cause number, issued letters of administration to the estate of Judy Kisembo, the Mary Kisembo. The deceased were survived by mother, now aged 75, and children Gloria Chirunji, Festo Chemba, and Edwin Ainebiona. Edwin Ainebiona is Mary Kisembo stepson. The widow lives with all the 3 children. Edwin has a very good bond with the widow. He does not know that she's not biological mother. Edwin's biological mother died while Edwin was 3 months old. Unfortunately, on 2011, Erin Katoka was committed to Butabika Hospital. She cannot make rational decisions. In early November, Sona Chinji was sentenced to 12 years. The mother was seized. She needs a diary regimen. Advise Mr. Deer on the remedies if available for her. What's the procedure? So basically here we shall look at we shall be looking at how basically do you get, because remember these things have been rendered inoperative. These things have been rendered inoperative. So inoperative, it basically means you have to proceed under section 230D, provided the court to revoke letters of administration that have become inoperative. And you have, in the matter of the estate of late Javaro Apollo Michael, the court stated that there is one way in which the name of the administrator of an estate can be removed from grant, and that is by revocation of the grant and making fresh grant. The procedure is to go in the forum is the High Court. Procedure is revocation under Article 230. But here we shall proceed by originating summons. Supported by an affidavit. So we shall have originating summons supported by an affidavit in support. So basically that's how we are going to be going through those workshops. That's basically what we shall be looking at. Originating summons supported by an affidavit in support. Then workshop 3, that's pass through workshop 3, the mood. By the end of this mood, you should be able to identify the grounds of revocation of probate and letters of administration before the High Court, draw appropriate pleadings for a suit for revocation of probate or letters of administration, draw a written statement of defense for the defendant, and file and prosecute the respective cases before the High Court. My name is Nicholas Mwavu. I'm 38. I live at Kawomo Village, Masaka District. I'm a son of Yona Simbi, who died on this one. My brother and sisters died on 29 when the boat they were traveling in capsized. My mother is alive. My paternal grandfather is still alive. My father left the following. We have the Sese broke his home, 30 acres of Bumbembe, 10 acres at Biama. Busuro broke commercial building in Masaka. In 2024, my stepmother, John Creva Muiya, made a report of death of my father to the Administrator General. He lied to the Administrator General that he was the only surviving child of my father. and that our family authorized him to obtain letters of administration. All the people who attended meetings in the office of the Administrator General were not our relatives. He later obtained letters of administration via ID Masaka High Court, probate, and administration cause number. This application for letters of administration did not include me or my mother or grandfather. After obtaining letters of administration, John Clever Muia registered all my father's land in his name. Muia sold the land known as Busiro to Don Mugiga. Samir's marriage statement, I bought land known as Busiro. I was approached by a broker called Silver. I consulted my lawyer Moses Mugezi, and he advised me to apply for an official search from the land. Motor documents, letters of administration, search report, and expert of certificate of titles. So, the students representing the plaintiffs shall prepare to proceed expert against the first defendant, John Clever Muia. Students representing the second defendant, Miss Muhari, must file written statement of defense. So basically here, of course, we are drafting a plaint supported by some of evidence, and the defense for the second would be that they are bona fide purchase of value without notice, whereas the plaintiff will be alleging that you failed to conduct proper due diligence, and this defense is not available to you. So basically that would be the synthesis or the thrust of the moot. It's just an expansion of what we have looked at throughout the week. They are proceeding to court to revoke the transactions which they believe were happened fraudulently, and this by pleading the defense of bona fide purchase of value without notice. So basically that's the moot, and that's all we can state. And in case you want to join a mastermind group, we run a mastermind group, and we have students in all campuses under our mentorship from Mbarara, Kampala, Lila, as well as Mbarara and Bari. So in case you want to be part of that group, you can inbox me on the number on this bio on 0756767284, and then members pay monthly subscription fee if that fits your budget. If it does not, wonderful, you can still do it your own way with your colleagues. But here, the benefit of joining this mastermind is that you get notes in time. You don't have to go and make research for notes. We give you summarized cases. We are also under tight preparation for oral exams. So I believe that what you can do in 1 week, we can cover it in 1 day. We can cover it in 1 day because we have been at LDC. We know what are your challenges, and we can make the work easier for you. But I implore you to continuously get better. I want, when I see you, we meet in practice, I see what a good lawyer this is. And if it can happen for me, it can happen for you. I also want you that when you see me in practice, or maybe 2 years from now, you say that I listened to this boy on his YouTube videos, but you should hear or see him now, and that the boy has worked on his craft. The boy has done extra reading. I see him 5 years ago. But you should see him now. The boy is really, or counsel is really intentional in becoming better. And the same thing can happen for you, and you have to be intentional about it. Perfection does not just come and land on you. You must be very intentional in becoming better every day. And how do I get better every day? How do you get better every day? By making sure that every day you learn a new thing. It could be reading a case. It could be becoming a better speaker. It could be improving your confidence by hitting your gym, by becoming better, increasing your spirituality, becoming a disciplined person. At the end of the day, all those ones contribute to the kind of person, to the kind of lawyer, to the kind of politician, to the kind of advocate, to the kind of businessman, to the kind of CEO, to the kind of whatever profession you want to be, you are going to become. But my advice for you from this video is continuously become better. Continuously become better. And if it can happen for me, it can happen for you. Please have a blessed week. I wish you success in your IAs.